What is data localization? Data localization practices are generally understood as requirements that confine data within a country's borders, stipulating that data needs to be processed or stored exclusively or non-exclusively within a jurisdiction. One of the main concerns with data localization is that there is not a single or harmonized definition for data localization. And although there is a wide understanding that this means processing or storing data within a specific jurisdiction, there are different views as to what type of measures would fall under data localization restrictions. For example, we have seen that there are some stakeholders in the industry that understand some more implicit measures like cross-border data transfers to be a form of data localization, because indirectly that could lead to more data being stored or processed domestically. And also, we have seen that there are different terms used to refer to data localization in the industry, such as data residency or even data sovereignty, although with minor difference, the drivers are generally the same. So, getting back to the point on data localization and cross-border data transfer, one of the most common misunderstandings we have seen is considering or confusing that data localization and cross-border data transfers are the same, thinking that if a country has established restrictions on transferring personal data abroad, this means directly that the country will have a data localization requirement. Although these two concepts are often very close linked, it's our understanding that they refer to different issues, and generally they are based on separate regulations. So starting with data localization requirements and what kind of data are under the scope of data localization laws, it's important to know that data localization laws applies to personal data and to any other types of personal data in generally. So even with a particular country or across regions, we can find different data localization measures applying to different set of data. This is very sector specific because we can find data localization restrictions in data pertaining to sectors such as telecommunications data, financial data, payments data, health data, or insurance data. And there are also cases where these restrictions apply to less defined categories, such as unimportant data, core data, or data processed by critical infrastructure operators or network operators. It's also important to know that the more sensitive the data is, such as health data, it is likely or it is usually subject to more restrictive data localization restrictions. And on the contrary, data that is less sensitive, such as business records, it's subject to less restrictions. How does this less work? Basically, as I said, there is a requirement for data to be stored or processed within a specific geographic location. And why? There are different reasons governments are invoking this law. Most of the times, data localization must be sought as a measure to protect information that is sensitive from a national security perspective, for example, to prevent data being accessed by other governments. Also, governments also promote data localization measures because they consider that operations and integrity of critical systems will be best guaranteed if they are processed and stored domestic. And also, they may mandate as well for data localization requirements with a view to ensuring access to that data for regulatory purposes. For example, to ensure that tax authorities can access information for that purposes, as well with insurance regulators or banking regulators, so the information is available to oversee activities in that sectors. Also, one important point of these data localization laws is that generally they have an extraterritorial scope, so it means that companies will be subject to multiple laws based on jurisdiction. For example, in the case of the airlines, this means being subject to multiple laws for a single passenger journey. So what's the difference with cross-border data transfers? First of all, cross-border data transfer or international data transfers generally focus on personal data because these restrictions are coming generally from data protection laws. As we all know, data transfer restrictions doesn't include a restriction per se, but it's more based on a condition basis. Like you can share the data outside as long as you comply with certain conditions. Most of the times, is to make sure that the country has an adequate level of protection as the country of origin, or in the most restrictive cases, making sure that the individual consent has been obtained, or that there are a pre-approved list of companies where the data can be shared. And unlike data localization, the main driver is to make sure that the receiving country has an equivalent level of protection as the country of origin, but regarding the fundamental rights of individuals. So nothing to do with national security. To help make sense of data localization requirements, we have developed the following approach to group countries based on how strict are their data localization requirements. So in level 1, we have all the countries where there are not any data localization requirements at all, or there are established certain conditions on access to specific types of information by means of certain security measures. So for example, we have in this category the Denmark's Bookkeeping Act, which include access requirements by the Danish public authorities, stating that they must be granted access when required. Or similarly, we have the New Zealand's Data Retention Regulation for business records, which establish that data can be stored outside of New Zealand, provided it meets certain integrity and access criteria. This level 1 largely covers data which is not sensitive at all, or that it does not refer to personal data at all. In level 2, we have countries where require local storage or processing of data, but without explicitly prohibiting concurrent storage or processing in other countries. Approach falling in this category, we may face business records, telecommunications, or financial data. For example, we have the United Kingdom's Company Act, which stipulates that accounting information can be stored abroad, but as long as a copy must be always kept in the United Kingdom. Or another example is the Electronic Health Records Act in Australia, which requires that health information must be stored in Australia, but also allows access to transfer that data outside and process that data outside, in case where such access is required by data subjects or by registered overseas healthcare providers. And in level 3, which is the most restrictive one, we have those countries where mandate local storage or processing, but also prohibit transfers to other countries, or only allow that transfers on very ad hoc authorizations or exceptions. The main difference with level 2 is that these countries are much more restrictive, and also that requirements apply to a wide range of data. Generally, they focus, as I mentioned before, on critical data, important data, core data, and they are also more ambiguous in terms of the scope. And generally, the countries which are located in this level 3, they have extraterritorial scope. So in this category, we can include China, Saudi Arabia, and Vietnam. An example of this is that the Vietnam privacy law, which has been effective from 1 of July 2025, established that core data and important data can only be transferred outside of Vietnam as long as it has the approval from the Prime Minister and also from the Ministry of Public Security following a security assessment. So following from the previous slide, you can see this world heat map where we have grouped the countries based on the different levels of data localization requirements that we have identified. As you will see, not all the countries has been highlighted because we have focused only on a global selection of major jurisdictions. And we believe this map is particularly useful in illustrating the global trend because approximately 75% of countries have now some sort of data localization requirements. At the same time, the main concern is that each country applies these laws completely different, so it's very difficult to predict a single or uniform approach. And furthermore, these laws are constantly evolving, and what we are seeing in terms of trends is that they are getting more complex and moving forward to a more fragmented global approach. In addition, we have identified 5 main sectors of data which is generally subject to data localization, which is basically personal data categories, business records, telecommunication data, public sector data, and financial data. And we have also seen more recently that critical data, important data, core data is something that it's been more aware in the privacy legislations, and also health data as well. So similarly to what we have done with data localization, let's look now at the other side of the coin and refer to main approaches to cross-border data transfer. So in level 1, we have the countries which are relatively open, so countries that have maintained open cross-border digital policy environments. In level 2, we have countries that have certain cross-border data transfer restrictions, but standard ones. And in level 3, we have countries that are highly restrictive, and that these barriers may include ad hoc authorization or very specific conditions. So, unsurprisingly, countries that they were highly restrictive in terms of data localization, they are the ones often enforcing very restrictive cross-border data transfers measures. So while it's difficult to provide an exact number, around 144 countries have some sort of privacy and security laws, which at the end, this leads to certain restrictions in terms of sharing data abroad. And although with cross-border data transfers, there are some common principles that it leads the legal framework when it comes to international data transfers, we are seeing that cross-border data transfers are becoming more complex because of the restrictive and divergent interpretation of privacy laws. Of course, this creates some operational burdens and challenge for the companies, potentially in sometimes obligating companies to segregate their product offering based on jurisdiction. And these evolving landscapes also makes companies to be very agile and very aware of these requirements, and also be prepared for different outcomes, including potential changes to these data transfer mechanisms. This fragmented approach is being made more challenging with a number of potential successful legal challenges, particularly with EU and US regions. As we know, there are certain concerns over the prospect of repeated invalidations of the EU-US personal data transfer mechanism and the imposition of other restrictions which could impose additional burdens to companies. And this is important because data transfer issues are becoming linked to a matter of trade, data sovereignty, and also a strategic alignment between different countries. I would like also to mention that we have also seen very recently that the US has also established certain outbound restrictions on transferring sensitive personal data to certain countries, deemed countries of concern. This is due to the known bulk data rule, which basically has been implemented in April 8, 2025, the Executive Order 14117, restricting the transfer of American sensitive personal data and United States government public data to 6 countries, which are China, Cuba, Iran, North Korea, Russia, and Venezuela. Basically, this involves transactions involving data brokerage, which basically refers to the sale of data, licensing of data, or commercial transactions. And although there is certain exceptions to this bulk data rule, this is something that companies will need to look very closely because it can create some operational challenges as well.